Over the last couple of lessons, we've been talking about the concept of pure economic loss and concluding that the general rule for pure economic loss, that is, loss that is only economic in nature, it is not attached to any kind of damage that is either physical, psychiatric, or maybe damage to property, that the general rule for pure economic loss is that there is no remedy available, there is no claim available. We then talked about the distinction that is made between pure economic loss on the one hand, where there is no claim available, and consequential economic loss on the other hand, where there can be a claim available. And consequential economic loss is, of course, loss which is consequential, as the name suggests, onto some kind of damage that is caused, either physical injury, maybe psychiatric harm, or even damage to property. This lesson is just going to talk about the development of the pure economic loss principles in a bit more detail, and we'll talk about some of the cases that have arisen out of these ideas, where we're looking at, for example, the case of Ans and Merton on one hand and Murphy and Brentwood on the other. So, the previous lesson specifically talked about the Spartan Steel case, where we made a clear distinction between this idea of pure economic loss and consequential economic loss. In fact, the Spartan Steel case is one of those rare instances where such a delineation is very, very easy to show, because there are lots of different instances where the claimants tried to make claim for loss, some of which were consequential, and so therefore were successful, others were not consequential, they were pure, and so therefore they were not successful. A very nice case that's neatly illustrates all of these different points. We're going to talk about two more cases in this video, and the reason why we're going to talk about two cases is because we want to show that the difficulty that the courts have had in actually making these delineations between pure and consequential economic loss. The Spartan Steel case made it look easy, because you have some instances where you have certain melts and certain steel that were of less value, and so were directly damaged by the negligent action, the cutting out of electricity on the main road. But then you also have instances where they tried to make a claim for future melts that had no specific damage attached to them, and so they were considered to be pure economic loss. So that distinction was made to look easy in the Spartan Steel case, but the delineations and determinations between these two different types of loss, economic loss specifically, aren't as easy to actually show. Ultimately, it's not always clear when and how the court should make a distinction between these two concepts. And the two cases that we're going to look at are the case of Ans and Merton on the one hand and Murphy and Brentwood on the other. And essentially what these cases, we've talked about Ans and Merton in more detail previously, but we'll talk about it in relation to pure economic loss in this video. And we'll talk about how this was overturned by the subsequent case, and really the trouble that the courts have had in trying to make determinations in this particular regard. So, in 1978, we have the case of Ans and Merton LBC. This case involves the claimants who had been the lessees of a block of flats. Now, the block of flats had ultimately had faulty foundations, and the faulty foundations in which they were built led to cracks in the buildings themselves. Merton LBC was the defendants, and they were sued for breach of their statutory duties. So there's generally there are tortious duties and tortious statutory duties in terms of approving building regulations and foundations, and so essentially they were sued for breaching their statutory duty in approving the foundations where it was clear that they were not deep enough to actually support the building that they were building on, and so as a result of which it was ultimately going to be the case that it would cause damage to the building, which was make it unsafe for the people who are living in the block of flats. Now, it was held by Lord Wilberforce that a two-stage test should be established for making determinations as to the existence of a duty of care in these specific circumstances. He says that the first question that you have to ask, the first stage of the test, is whether or not there is a sufficient amount of proximity or neighbourhood between the claimant and the defendant, such that the defendant should reasonably foresee their actions would likely cause damage to the claimant. That's on the one hand. And then the second question is, are there any considerations which may limit or negate the duty of care to be found? So, this was the basic duty of care test that we looked at, and when we were talking about the development of duty of care within the English law, we touched on that in previous lessons. But then, in addition to this test, there was issues in relation to the establishment of the idea of pure economic loss. So not only was there conversation about the establishment of a duty of care, this case also illustrates the difficulty that is had when we talk about pure economic loss, because in the case itself, the House of Lords used the language of, quote, material physical damage when they were referring to the damages that the council will have to compensate in essentially finding for the claimants. And so, ultimately, the House of Lords made no distinction here between physical damage to property and the defective property, which was the conditions of the flats itself. Now, essentially, this is something that's interesting when we think about the law of contract, but ultimately this case is altered, okay? And the claim for actionable damage in negligence would later be rejected by the 1991 case of Murphy and Brentwood, DC. In this case, you have a very similar set of circumstances, a very similar set of facts. Essentially, the claimant had been the purchaser of the house. The house, again, was built on poor foundations. This decision to build on said property was one which was approved by the council, so they had been negligent in making that approval, leading to the poor foundations on the property. And so when it came to the sale of the property, it was found that a significant cost would be required to restore the foundations of that property for sale. So the claimants then sued the council for negligently approving of those poor foundations in the first place for the damages of the significant cost that would have to have been essentially instigated in order to restore those foundations to make it suitable for sale. And it was held by the courts that the position in Ans and Murden was wrong, and they rejected that position and instead concluded that this was a case where there was pure economic loss. And so it was held that because the house was built on the foundations, there was no damage to the property, given the fact that the property was always damaged. Because the property itself didn't exist until it was built, obviously, and it was only ever built on poor foundations, it was always damaged. So there was not a situation where you have a house where it is worth a certain amount of value, and then somebody through their own negligence comes in and then damages that property, which then reduces its value and then causes economic loss. That would be consequential. But what they argued was that the property was always damaged and it was always poor on poor foundations, and so there was no damage to the property that such situated and led to a situation, shall I say, where you have consequential economic loss. There was always pure economic loss, and so as a result of this, the claimant actually had no claim to be answered for.